Mr. Edwin Tong, SC, Minister for Culture, Community and Youth, and Second Minister for Law, Justice Philip Jeyaretnam, President of the SICC, ladies and gentlemen, good afternoon. And to those that are with us online from Europe, good morning, good afternoon from India, as well as good evening for those with us from Australia. I'm so glad that, in a sense, one of the positive outcomes of COVID-19 was that we're now getting used to both in-person as well as virtual, where we can share messages as well as key communication, not just within Singapore, but internationally, to which all the three institutions have our own stakeholders based, right? Now, Singapore has done much to establish ourselves as a trusted neutral forum for international dispute resolution, or what we call IDR. The Singapore International Arbitration Centre, SIAC, is one of the most preferred arbitration institutions globally. And at the Singapore International Mediation Centre, the SIMC, the value of disputes filed for mediation has increased substantially. Just last year, 2021 alone, I still think I'm in 2022, this figure was $3 billion US, equaling the total dispute value for the previous 6 years from when they started in 2014 to 2020. Just last year itself, the total dispute value exceeded 4.84 billion, which makes Wee Ming and Junie really busy trying to keep up with things, as well as ensuring the SIMC keeps growing. Yeah. So growing in tandem, in the latest of a series of legislative reforms, the Singapore International Commercial Court, or the SICC, introduced a standalone set of procedural rules, which we call the SICC Rules 2021, which enhanced procedural flexibility and highlighted international best practices in the court, such as protocols for highly complex disputes. Now, this triumvirate of institutions, the SIAC, SIMC, and SICC, have worked together to advance Singapore as a truly effective Asian hub for dispute resolution. And between Gloria, Wee Ming, and myself, we've worked with MinLaw internationally, but I think this is the first time that we are actually coming together on a Singapore platform. So long may we have more of these exchanges and how we develop things along. So the interface between these three IDR centers is further strengthened today by two initiatives that we have. As part of the ADR-friendly nature of the SICC rules, SIMC and SICC are jointly introducing the Litigation-Mediation-Litigation protocol, or LIT-MAT-LIT, or we have shortened it to just LML, okay? For many of you here, I think you should be relatively familiar with the whole procedure because you've heard of ART-MAT-ART for years. I think we're just completing the whole circle and having a LIT-MAT-LIT aspect to that. The second initiative arises from the increasing number of matters being heard by the SICC on international arbitrations that are seated in Singapore, since this jurisdiction was extended to the SICC from November 2018 under the IAA Act 1994. So SICC will be introducing a model clause for the SICC to be the supervisory court for IAA-related matters, and SIAC will be introducing an additional option to its model clause for parties to incorporate the same. So this is where it is, where on the registration table, if not taken, we have a very brief infographic on the LIT-MAT-LIT protocol, as well as a very simple one page that contains both the model clause for the SICC in general and the inclusion of an option within the SIAC model clause page, right? It's simplicity in itself, a simple one paragraph to help, so please look at that. And we are very pleased this evening that Minister Tong has agreed to give some opening remarks on this one. He definitely needs no introduction, but just as a sort of context, putting in context, his presence here is because at the Ministry of Law, he focuses on development and promotion of Singapore's legal and dispute resolution sector, aka, where it's concerned, SIAC, SIMC, and SICC, right? He also handles wide-ranging aspects of law reform, such as intellectual property, corporate restructuring and insolvency, as well as legal aid. But on today's part, and especially on this, how we are working together to keep enhancing, enriching, and ensuring that Singapore remains the most trusted neutral forum, especially within Asia, for international dispute resolution. Please help us to welcome Minister Tong for his opening remarks. I won't shake your hand. Yeah, please don't.
Thank you, Lawrence. I wasn't aware that it's the first time locally that MinLaw is here together with SICC, AC, and MC. The last time I had occasion to speak on the same platform as Lawrence was in Delhi. He arrived, but his luggage did not. And so his clothes didn't arrive.
Thank you.
But he was completely unfazed, and he spoke as eloquently as he has just done in his same clothes throughout. And I think that's a reflection of the dedication and of the determination to ensure that he puts SICC and indeed the rest of the IDR institutions on the map internationally. Good evening, Justice Philip Jeyaretnam, President of the SICC, Ms. Gloria Lim, CEO of SIAC, Mr. Tran Wee Ming, CEO of SIMC, Lawrence, SICC, friends, colleagues, distinguished guests, ladies and gentlemen. It's great to be here this evening to support this institution, this what we regard as a triumvirate of dispute resolution institutions. As the saying goes, good things comes in threes. Whether you have fairy tales, like the Three Little Pigs, or Aladdin and the Three Lambs, Three Wishes, or Goldilocks and the Three Little Bears, to blockbusters like Lord of the Rings, Back to the Future, Godfather, Star Wars, I mean, you name it. But that's not the reason why we had three dispute resolution institutions. We had the three because we were focused on what commercial parties wanted, whether it's mediation, arbitration, or international commercial court resolution mechanisms. And as the title of today's event suggests, if you look up the screen here, ADR doesn't stand for alternative dispute resolution. It stands for appropriate dispute resolution, which I felt was a lot more appropriate, to borrow the phrase. What is the most appropriate dispute resolution mechanism for a particular case may not always be the same, even if it was the same party, and perhaps even in the context of a similar case. There may be many considerations involved, such as the counterparty, the nature of the bargain, the particular circumstances of the individual or the client that's involved in trying to resolve the dispute. Therefore, what we strive to offer is really to have a ready selection of tools in the toolbox, able, ready, and willing to meet and deal with the situation at hand. And we may not always have those tools, but we can have the most essential ones that will resolve a majority of the disputes either on its own or in combination with one another. In dispute resolution, mixed mode or hybrid mechanisms have become more prevalent. You heard Lawrence speak earlier. Let me say a little bit about it. A survey conducted by the Singapore International Dispute Resolution Academy, or SIDRA, in 2022 found that the preservation of business relationship, cost, speed, and flexibility were key factors why parties chose hybrid mechanisms over standalone mechanisms. Obviously, a lot of this has got to be influenced by what's happened in the last 2.5 years or so with COVID. But nonetheless, I think these are all measures that we should assume in a post-COVID environment will stay. And I think those choices must influence and must tell us how we would like to shape the three institutions' offerings to clients. SIAC and SIMC introduced the ARP-MET-ARP protocol in 2014 at the time that the SIMC was set up. And as I'm sure all of you know, ARP-MET-ARP simply means that a dispute is first referred to arbitration, and then mediation is attempted. And if you're able to find a concluded mediated agreement, that mediated settlement agreement is then recorded as a consent award, which is then enforceable in 171 contracting states under the New York Convention. Now, we've had to do that previously because you wanted an arbitral award that you could then use the New York Convention to enforce. That was before the time of the Singapore Convention on Mediation. Of course, with the SCM, it's in place, but with the still relatively nascent stage of SCM and the number of countries that have signed up to it, it will take some time for each of these countries despite having signed on to it, to ratify, and to put their own set of domestic legislation in place to support it. So it is in that context that I'm very glad that SICC and SIMC have come up with the Lit protocol, or LML, as Lawrence puts it, adding what I believe to be yet another important tool in this toolkit. Similar to the Up protocol, parties will commence proceedings with the SICC or at the SICC, which are then stayed for mediation in the appropriate cases. If the dispute is subsequently resolved by mediation, then the mediated settlement agreement can be recorded as an order of court. Another product which will be launched today is the SICC Model Jurisdiction Clause for international arbitration matters. It provides for any court proceedings in Singapore commenced under the International Arbitration Act, 1994 version, in relation to the arbitration to be commenced before the SICC and to be heard and adjudicated by the SICC. This really came as a result of feedback from the ground, really from each of you, users on the ground, from both local and foreign practitioners who are of the view that the ability to designate SICC as a supervisory court for IAA matters would be appropriate in some cases. It gives options to parties. The SICC bench consists of not just local judges, but a whole deep bench strength of international judges from both the common law as well as civil law jurisdictions from around the world. They have rich experience in different fields. They have deep expertise, particularly in foreign laws and other matters, and those come in very useful when hearing matters related to cross-border cases with foreign law elements. And the ability of the SICC to provide that curial support for arbitration matters, particularly high-value cross-border international arbitration matters, will be quite invaluable. So this model clause, in my view, will significantly advance the ability of parties to harness and use that mechanism well. Indeed, the judicial support and recognition of international arbitration is really one of the reasons why Singapore has grown to be and remains one of the more attractive arbitration hubs today. We all know that arbitration is chosen by parties, and it is a product of party autonomy, party choice. And there is no question that our courts are pro-party autonomy and therefore pro-arbitration, where parties have validly and properly chosen arbitration as the appropriate mechanism for resolving their dispute. The courts in Singapore constantly and reliably uphold parties' agreements to arbitrate and offer maximum judicial support with minimal intervention in international arbitration proceedings. I've had my own experience when I was in practice. I mean, you try coming to court to set aside an arbitral award without basis, without merit, just so that you can buy some time. I think you know what will happen to you, not just in terms of adverse orders, adverse cost orders, but broader implications. And I think that's an important principle to keep close to. With the additional judicial support from the SICC, I believe that this can only enhance our value proposition to give confidence to parties that their choice, their chosen mechanism will be upheld and will not be willy-nilly interfered with. In the spirit of what I said at the start, all good things come in threes, and no, I'm not going to tell you a fairy tale. I see Francis laughing away. I'll keep that for another time. I thought I would end by sharing three key takeaways, partly from today's launch, but also partly in the spirit that we are taking this session at the start of a brand new year, looking ahead at 2023, post-COVID, almost post-COVID, I must say. I'm not allowed, by the government to say that we are entirely post-COVID because we're not out of it yet, but we're almost there. And I think whilst we look ahead with a lot of confidence, I should also say, have a look back as well to make sure that the problems that we had for the past 2.5 years or so don't visit upon us again. But in that spirit, let me just share three quick thoughts with you. The first is I believe we can all benefit tremendously from ground-up initiatives. As I said at the outset, the whole construct, I moved from practice into government, and the whole construct, the whole philosophy behind almost every piece of legislation that we look at, particularly those like the IAA or those that deal with industry, is aimed at ensuring that parties' commercial needs are met. And we look at that very carefully and somewhat jealously as well. So our regime, our framework, our policies, incentives, initiatives are really geared towards the end user. What does the end user want? What can Singapore, as a dispute resolution hub, offer the end user in Singapore? And we therefore take a practical rather than theoretical approach to things. I mentioned earlier that the choice of SICC as a supervising court came from feedback. It was from sessions not dissimilar to this, where people tell us that why not designate SICC because of the depth of experience and the range of expertise in foreign law matters. And so we did that after studying it. The two new products that we're launching today are very good examples of this. We know that they will be very useful, very helpful, because they did come as feedback from actual users operating at the front lines, like many of you. So my first leave behind for you is, if you have further feedback, suggestions, ideas in your practice as you deal with clients overseas, as you engage in matters overseas as well, and experience overseas jurisdiction and legal systems, take back to us what you think might work for us. Share your experience with us. Tell us what your clients think of our system. Tell us what your clients think of other systems, and whether we could bring, as best practices, features into our own system as well. And that is a constantly evolving process between users like you, front end, the bench, who looks at cases when they come before them, and ourselves in government, as we deal with policy, we deal with frameworks, and as I said, initiatives and also incentives to promote arbitration, mediation, as well as international commercial court resolution in Singapore. Second, I would say we can achieve much more if we achieve it as a collective group. We call it Team Singapore. And when I say Team Singapore, it includes all the lawyers from overseas jurisdictions who operate in Singapore. All of us are part of the same jurisdiction, trying to make this jurisdiction work and trying to bring work into this jurisdiction. And I would say not just the three institutions today, SICC, SIMC, and SIAC, but also the broader legal ecosystem. SEMA, SIMI, SIMI, SIDRA, which I mentioned, SIR, Maxwell Chambers, and others, all coming together to make it a Team Singapore dispute resolution offering. I would say collectively they have already punched above their weight and made their mark both regionally as well as internationally. And I think there's deep respect and deep regard for many of our institutions. And on the trips that I've made, just recently, in the last couple of months, I mentioned Delhi, I was also in Hong Kong. I would say there is deep respect and deep regard for what we have achieved there. But at the same time, I would say never rest on these laurels, because things move very quickly, and we've got to respond equally quickly to market forces, market changes. And that, in part, was why I raised the first point with you, to come and give us your views, give us your feedback, give us your suggestions on a timely basis. One other message about this is a small country, a small community. And really our resources are too limited to be trying to do the same thing all the time. Understanding the needs of the same markets from different perspectives, albeit, but the same markets. Getting feedback from the same users, or marketing our services to the same people. So instead, why not harness and turn our small size, our smallness, into a strength, which I feel we can do. And it is precisely because we are small, and in Singapore, the added advantage of being small is that we are tight-knit, close. The bench and the bar and government, academia, very close. And we can work together productively. Why not share our experiences and our feedback, cross-sell, cross-market even each other? I mean, there's no reason why SICC and SIMC should not do so, because after all, it is lit, met, lit. Or in the case of SIAC, up, met, up. So there is a lot of synergy in what each of us do collectively. And I think if we bring that together and harness it, together we can collectively be greater than the sum of its parts. In fact, I just make one other passing point. When I was in Hong Kong and I made some speeches, that's precisely what I said in Hong Kong too. We are both a jurisdiction of choice when it comes to dispute resolution, financial center, and similarities in many ways. Therefore, the competition is obvious. But at the same time, the point I made to many practitioners in Hong Kong, as well as government officials, is that there is at once a synergy in what we do. If they succeed, we succeed, and vice versa. They are a gateway into Greater China. We are a gateway into Southeast Asia. There's a lot of synergy between what we can do as friendly competitors, but we could still collaborate to complement and benefit one another, working on leveraging and relying on our respective strengths. And I think that same principle holds true in this room, within Singapore, amongst our own institutions, and the bar, and the bench, and government. Third, my final point is that we have over the years, and I think we've been fortunate to have over the years, a very strong foundation. We've built strong bases, we've had good fundamentals, and we worked, I mean, you think back to the years when we started SIAC, it was just kept to domestic counsel. We then broadened it, and broadened it even more, and we worked our way such that SIAC becomes arbitration in Singapore, in fact, not just SIAC, becomes not just the remit of local lawyers, because we want the best to be in Singapore. If you take SIAC, look at the composition of the board or the arbitrators on the panel, they are not the best of Singapore, they are the best of the world. And we do that consciously because we are agnostic to where you come from, as long as you are the best. And so that principle has to apply. If not, we cannot be parochial about things, we've got to be outward looking. And I believe that we've got within us in Singapore already a very strong foundation. And I don't just mean the hardware. You know, we have, the hardware is non-negotiable. Governance, strong rule of law, business-friendly laws, a vibrant business hub, and so on. All non-negotiable. We've built that, we should maintain that. But we have our software as well, our people. I mentioned our close-knit fraternity. But the ability to move fast once we decide on something gives us a competitive advantage. Take the SICC as an example. First mooted, I think, opening of legal year in January 2013. Almost within months, it went into overdrive, setting up a committee, look at it, between ministry, judges, in-house counsel, academia, the bar, and so on, coming together to study the framework, give ideas, give input. And by November 2013, just barely a few months after the committee was set up, report was ready, recommendations made, did a public consultation, framework was then published, and SICC started operations by January 2015. It's this kind of courage of conviction and this kind of unity and the ability to move when we've decided collectively that we want to move, we need to move, and we know where to move to, that gives us an advantage. And I think we should continue to build on that foundation. So I hope that we will be able to take advantage of and build from this very solid base that we have today to look at something even better. As I said, collectively greater than the sum of its parts. On the part of government, we remain committed to safeguarding that strong foundation, whether it is in the hardware, as I said, non-negotiable, or strong adherence to rule of law and governance, and so on, but also continually enhancing the regime, looking at it from the angle of not just government and policy, but being out there, dealing with you, hearing from you, receiving feedback from each of you who deal with your clients in different jurisdictions, to ensure that we continue to evolve, enhance, and make ready a system that users will see value in, and want to be here and using Singapore, whichever is the mechanism of choice. So with that, let me end here. Thank you very much for listening to me, inviting me here to share some thoughts in this session. And I look forward to Honourable Judge's session as well. Excuse me that I will have to leave after that session for another function. I think as the year opens up, there's a real pent-up demand for functions and events. And every other little function or event is a gala this or a gala that, you know. So there are a couple of these engagements this week, so please excuse me. But thank you very much.
Thank you very much, Minister Edwin Tong, for your time and for that rousing speech. This is also the first time that we're sharing the rostrum since my pupillage with you some 18 years ago. Justice Philip Jeyaretnam, guests, ladies and gentlemen, it is my distinct pleasure to introduce the keynote speaker, Justice Philip Jeyaretnam, Senior Counsel. Justice Jeyaretnam was appointed Judicial Commissioner of the Supreme Court on the 4th of January 2021, and after passing his probation, was appointed High Court Judge on 1st November 2021. In June 2022, he was appointed by the Chief Justice as the co-chair of the Commercial Practice Panel of the Supreme Court to develop best practices for the management of commercial cases in the courts. And just this year, 2023, Justice Jeyaretnam was appointed President of the Singapore International Commercial Court. Alongside his enormous judicial duties, he's also a member of the Judicial Service Commission and the Presidential Council for Minority Rights. Prior to joining the bench, Justice Jeyaretnam was well known to many of us as a superb lawyer. He was recognized as senior counsel in 2003, and in the years prior to his elevation, he was first managing partner of Rodike, and then ASEAN CEO and global vice chair of Dentons after its merger. Perhaps more significantly, he was also known for his integrity, his fairness, and his gentlemanly conduct towards other lawyers, qualities that led the Law Society in December 2020 to confer the C.C. Tan Award on him. I could go on, but I am not the main event, and there is a Wikipedia page that you can go to that lists all his other achievements, including his accolades for his fictional writing, which, for the avoidance of doubt, is not a reference to his judicial writing. Please join me in welcoming Justice Jeyaretnam to deliver his speech. Thank you.
Well, thank you very much, Paul, for that introduction. And thank you, Minister Edwin Tong, for joining us today. Your speech was substantial. It drew upon not only your the depth of your knowledge and commitment in government, but also your many years in the profession and your deep understanding of what makes the profession work and how indeed business and industry, what business and industry find useful and helpful when coming into the legal system, those encounters that they have with the legal system. So thank you very much, Minister. The launch of the LML protocol between SICC and the SIMC, together with the launch of our model clause for international arbitration matters, reflects the importance of offering business users of dispute resolution services clear and flexible pathways between these three principal modes of dispute resolution: mediation, arbitration, and litigation. And disputes, they come in all shapes and sizes, and for this reason alone, one size does not fit all. The LML protocol provides for a party commencing proceedings in the SICC to have them stayed for a few weeks in order to refer the dispute for mediation at SIMC, and any resulting settlement agreement may then be recorded as an order of court. The SICC model clause, it's simple and straightforward. It makes sense also for parties to combine it with the SIAC model clause, and this combined choice of arbitral institution and supervisory court will, I'm told, be put up on the SIAC website in the coming days. I'd like to thank the members of the SIAC working group, and particularly the initiative at the start of Paul Tan in suggesting this. And 9 lawyers drawn from Singapore and the foreign law practices worked with us to develop the clause. And I would say that, echoing what Minister Tong has said, it's been input from the profession that has helped make sure that it is useful and relevant for lawyers and their clients. And our theme today is appropriate dispute resolution, and the adjective appropriate is there for a reason. It avoids the oppositional adjective of alternative. It's true that litigation in court is the natural avenue for redress in a developed society, because access to justice forms part of the social contract between citizens among themselves and with their elected government. Moreover, court litigation is conducted openly, transparently, results in reasoned decisions that are publicly available. And all of this helps guide future conduct. And for these, among other reasons, the courts do anchor the legal system. Nonetheless, other modes of dispute resolution may be more appropriate in specific circumstances, and consequently, it's helpful to think in terms of appropriate dispute resolution rather than alternative dispute resolution. And in my address today, I'll make 3 points. First, mediation is useful even if it does not resolve the entire dispute, because it may save time and cost by settling some parts of a larger dispute. Secondly, arbitrators must have the confidence to exercise their procedural discretion so that they can achieve substantial justice. And thirdly, lawyers, regardless of whether the mode of dispute resolution adopted is in court or outside court, must keep top of mind their role in the administration of justice. And it's worth keeping in mind that any discussion of systems of justice requires consideration of at least 2 perspectives. One is society's interest in an objectively fair and efficient process. The other is the individual litigant's subjective interest, not only in fairness, but also in winning. And there's a tension between the 2 perspectives because litigants and their lawyers will inevitably seek advantage, and processes must be designed to minimize how those processes might be gamed or manipulated. On this last concern, it is important that the legal profession inculcate from generation to generation the culture that lawyers are an integral part of the administration of justice, and therefore share responsibility for a fair and efficient process. And this appreciation is part of what gives purpose to a legal career. So first of all, mediation is a way of managing and simplifying complex disputes. Courts and other tribunals find their origin in the human desire that injustices be remedied. We speak of doing justice, but what we really mean is remedying injustice, stopping one person from infringing the rights of another, or compensating the victim for the infringement. Mediation in and of itself has only an indirect relationship to justice, because it focuses not purely on the rights of parties, but also on their interests, regardless of their strict legal rights. On one hand, this makes mediation attractive, with the potential to rescue parties from the zero-sum game of a formal adjudication where one party must lose in order that the other may win. On the other, however, if mediation is unmoored from the legal system and the possibility of redress in court is cut off, it may favor the party with greater bargaining power and so advantage the strong over the weak. Where seeking legal remedies takes too long or is too costly, then mediated outcomes that involve compromise become more attractive, but not for the right reason. Hence, it is necessary to anchor mediation within the broader context of a fair and efficient court system. Parties who know that the legal case can, in principle, be fully litigated will be better placed to reach just mediated outcomes, accommodating both parties' interests and not overriding either party's desire for justice. Given this context, mediation of disputes that have already been brought before a court, done with the encouragement and ultimately the supervision of that court, carries the benefit that parties knowing and understanding their rights may nonetheless find it in their interests to resolve their dispute without pursuing the fight to the bitter end. Commercial relationships may be preserved, time and cost may be saved. Mediating in the context of an ongoing litigation at the suggestion or direction of the court has several additional benefits. One is that because mediation is suggested or directed by the court, the problem that neither party wants to be the first to suggest it, in case this is perceived as weakness, is sidestepped. A second benefit is that filing proceedings helps parties shape and define the contours of their case, so that the issues for mediation are properly established. A common difficulty with mediating in the early stages of a dispute is that parties do not have enough information, not just about their own case, but also about that of the opposing party. And I'd make 3 additional observations. First, it's important to stress that mediation must be something that takes place separately from the proceedings happening in front of those mandated to adjudicate on the dispute. Successful mediation requires the mediator to be let in to the confidence of each side. and into the confidence of each side in turn, in the absence of the other. This is antithetical to the general principles of fair hearing on which adjudicative processes are based. Secondly, while in principle courts may be given the power to direct unwilling parties to mediate, a fact which is actually no more objectionable than enforcing a prior agreement to mediate contained in a contract, in practical terms, ordering a mediation where one of the parties is adamant that it will not settle and wants to litigate its rights is likely to be a waste of time, and this merely delays that adamant party's access to justice without any countervailing benefit. Thirdly, while it can be said that there is a time in any dispute where parties are more likely to settle successfully, a sweet spot, if you like, occurring after they know enough about their respective cases and before they have descended into an unbridgeable hostility, well, exactly when this sweet spot occurs is likely to differ from case to case and from party to party. And this means that predetermining whether by contract or by rules of court when mediation should occur may not be the best approach. Instead, there should be procedural flexibility of two kinds. First, in the processes of the adjudicative body, to consider with counsel the desirability of mediation at different stages of the process, and secondly, in the processes of the mediating body, to carry out mediation quickly and efficiently, regardless of the stage of the dispute. And I'm happy to report that the SICC and the SIMC have the requisite respective procedural flexibility. I turn now to the main point I want to make in this section. There are disputes that are of such complexity that they are difficult to resolve fairly and efficiently by one mode alone. For such disputes, the possibility of mediating certain aspects of a dispute while leaving others to be fully litigated is truly beneficial. A good example would be technically complex construction disputes where there are contractual aspects, defects aspects, and delay aspects. It can be difficult to the point of impossibility, or at least inefficiently costly, for all aspects of such a dispute to be determined by the same adjudicator in one big set-piece battle. In these circumstances, parts of the dispute can be hived off for other modes of dispute resolution, and this can be done in different sequences, different steps, depending upon the dispute and what parties, after consideration with the adjudicator, consider to be the most appropriate way forward. And mediation is definitely one of those potential avenues to deal with certain parts of a dispute. There are other methods, for example, neutral evaluation, which can help to resolve certain kinds of disputes. But mediation has certain advantages. With neutral evaluation, parties may be reluctant to lose the option of agreeing or disagreeing to the outcome that happens when you select binding neutral evaluation. But a non-binding evaluation, because the outcome comes all at once as a singular outcome, that outcome may not be accepted by the party who feels it has not had its way. Mediation offers a potentially more nuanced approach in which parties feel they have control. It can be very effective. I turn then to arbitrators' procedural discretion. And this is a key positive feature of arbitration, that they have that discretion to establish a fair and efficient procedure that fits the circumstances of the case and the needs and means of the parties. It's through the exercise of this discretion that many helpful innovations were developed, which have since spread beyond the world of arbitration. And two simple examples of this suffice. One is witness conferencing, where the expert witnesses of all parties in one discipline testify together, rather than sequentially during presentation of the parties' cases. The traditional practice meant that expert witnesses might testify days or weeks apart, and witness conferencing was developed in arbitration and is now commonplace in courts around the world. And it's very helpful in getting to the right answers because it eliminates the risk of experts simply talking past each other. It also fosters candor and realism on the part of the experts. Add to this the point that experts asking direct questions of each other rather than through lawyers can, when properly handled by the adjudicator, really elucidate the technical issues in the matter. Second example is time limits for evidence taking. In arbitration, this is usually done by the so-called chess clock method. The equal allocation of time is considered by arbitrators to be the simplest demonstration of fairness to both parties. Courts increasingly adopt time banking, where the use of time during trials is planned and allocated in advance in consultation with counsel. In my view, in arbitrations as in court, equality of time is not really an essential feature. One side may have more witnesses than the other. More witnesses may require more time for cross-examination. So what is truly essential is fair and due consideration in consultation with counsel of what the appropriate allocation of time is. And this can be readily demonstrated at the time of making the allocation. Now, given that arbitrators' procedural discretion has delivered so many innovations that have been of great value to fair and efficient dispute resolution, it's concerning to hear talk of defensive arbitration, a phrase that evokes defensive medicine where doctors said to be worried about being sued for negligence, order unnecessary tests, increasing costs for patients. In defensive arbitration, an arbitrator worried about a natural justice challenge may also fall into bad practices, of which I give 3 examples. First, permitting excessive rounds of evidence and submissions at the expense of time and costs. Secondly, allowing timelines to slip as a recalcitrant party delays proceedings. And thirdly, not daring to ask questions or raise concerns to counsel, or refraining from inviting additional submissions when these are necessary to get to the heart of the matter, a quest that is certainly in the interests of justice. Practicing defensive arbitration is in fact unwarranted. The courts only set aside arbitration awards where this is mandated by the law, and the grounds for challenge are narrow. In truth, courts are acting to protect the integrity of the arbitration process when they set aside awards on the basis of proven due process failures. There's nothing in the law and practice surrounding the natural justice ground that should hinder or impede arbitrators from acting fairly and efficiently. It may be that sometimes unhappy parties find a way to shoehorn their unhappiness into a natural justice challenge, but such unmerited applications do not succeed. And reference to the SIAC rules, 2016 Rule 19.1 is salutary, and I just quote that. The tribunal shall conduct the arbitration in such manner as it considers appropriate after consulting with the parties to ensure the fair, expeditious, economical, and final resolution of the dispute. And I would say that fulfilling this rule is a core duty of the tribunal, and it is completely consistent with the demands of natural justice. My third point concerns the role of lawyers and their shared responsibility for a fair and efficient process. Under the professional conduct rules, counsel owe a duty to assist in the administration of justice in proceedings before the court and any tribunal. Rule 9.1e states as a general principle that a legal practitioner must, in any proceedings before a court or tribunal, conduct the legal practitioner's case in a manner which maintains the fairness, integrity, and efficiency of those proceedings, and which is consistent with due process. And this, in turn, is a core duty of counsel. It's worth elaborating what this means in practice within proceedings, whether before a court or a tribunal, and I'd note 3 points. First, in relation to timelines for filing documents, counsel must not seek excessive time. Secondly, in relation to fixing of hearings, counsel must make themselves reasonably available, and where this is not possible, they should be open to arrangements for other counsel to handle the hearing in their place. And thirdly, in relation to requests or requirements that counsel agree procedural documents, such as lists of issues or statements of agreed facts, counsel must approach the task in a spirit of good faith and genuine cooperation. But there is a further overarching point that is relevant to our topic today, which is appropriate dispute resolution. Appropriate dispute resolution involves helping parties in dispute move towards the fair and efficient resolution of that dispute by the pathway most appropriate to the circumstances, including the nature of the case and the situation of the parties. Lawyers are guides. and have a responsibility to their clients to find the shortest, smoothest path to achieving a fair and just outcome. Thus, lawyers must advise clients on the possible modes of dispute resolution and do so at appropriate junctures so that time and cost may be saved. In conclusion, today marks a milestone of coordination among institutions that offer parties different pathways to the resolution of their disputes, providing linkages and crossover points that make it easier for parties to navigate. And I thank SIAC and SIMC for their partnership in our shared aspiration that international commercial disputes find a natural and safe harbor in Singapore for their fair and efficient resolution. And I thank all of you for being here, and I look forward to the panel that follows and to the tea that follows that. Thank you.
Thank you, Justice Jeyaretnam. Yes, following from the wonderful opening remarks by Minister Tong and the elucidating views from Justice Jeyaretnam that you have heard on appropriate dispute resolution, I'm looking forward to the next session, which is a fireside chat, and that promises to be. I'll leave that to you to decide. Actually, to moderate it as well as to provide practitioners' perspective to appropriate dispute resolution the Singapore way, we have Siraj Omar, SC. Firstly, my personal congratulations to Siraj on being made Managing Director for Dispute Resolution for Drew & Napier. I think just a few days ago, only or last week. He has been quite modest. It was only a small announcement in LinkedIn, I believe. So he has more than 25 years' experience in complex, high-value commercial disputes. He's been active trial and appellate practice in the Singapore courts and has litigated many landmark disputes before the courts in areas as diverse as banking, consumer protection, debt restructuring, and insurance. He also has a very active international arbitration practice, appearing as counsel as well as sitting as arbitrator. He serves on the board of directors of SIAC and is a member of its board executive committee, and also holds fellowship in SIAC, SIAC, as well as Singapore Academy of Law. So, most well-placed to talk about appropriate dispute resolution, given that, except I think Wee Ming's dying to persuade him more to look into mediation beyond his current practice in arbitration and litigator. Can I ask Siraj to please come up and take the first seat as I introduce the rest of the panel on nearest to the right. Thank you, Siraj. Secondly, definitely familiar to all of us is Gloria Lim, CEO of SIAC. So as Chief Executive Officer of SIAC, she works closely with the Chairman and the Board in formulating and fulfilling the vision and strategies for the SIAC, and so responsible for institutions' overall management and operations. But we know beyond that, she's also very much the face of SIAC. A little bit about past, for those who don't know, she was previously Director of Legal Industry Division in Singapore's Ministry of Law, and concurrently held the statutory appointment of Director of Legal Services, heading its Legal Services Regulatory Authority. So, as Director of the Legal Industry Division, she oversaw the development of Singapore's legal sector, including development and promotion of Singapore's international dispute resolution regime. Without much further ado, can I ask Gloria to join us on the stage as the second member of the panel. Third seat. Yep. And the other part of, the other half or the last of the triumvirate, Chuan Wee Ming, CEO of SIMC. Wee Ming is an experienced general counsel of almost 30 years, working in Beijing, Hong Kong, and Singapore. He speaks with a perfect Beijing Jiang, I understand, right? So no issues and no need to translate whenever he meets with the Chinese parties. He has advised senior leaderships at multinational corporations as lead counsel on legal and regulatory issues arising out of doing business in China, Hong Kong, Taiwan, India, Japan, Korea, ASEAN as a whole, Australia and New Zealand. So On this one, and also the face of the SIMC internationally, can I invite Wee Ming up onto stage as the third panel, fireside chat panelist. And lastly, but definitely not the least, Justice Jeyaretnam to join us. And with that, Siraj, over to you.
Thank you, Lawrence, for that kind and very unnecessary introduction for me. I should say I'm co-managing director of disputes. Thank you very much. It is a pleasure to help moderate and be a part of this panel with members who don't need an introduction, and following on from Minister's theme of three, representatives of the three pillars of the dispute resolution ecosystem in Singapore. His Honour Justice Jeyaretnam from the courts, Wee Ming from the Mediation Centre, and Gloria from SIAC. I do recognize we are running a little late and that we stand between yourselves and tea and meeting fellow practitioners, so I think we will keep this short and focused. And to start us off, maybe I could start by mentioning what Justice Jeyaretnam has said in his keynote about how disputes is not a one-size-fits-all proposition, and of the need to ensure that there were clear and flexible pathways for the users of Singapore's dispute resolution services. Some view these pathways as being mutually exclusive. And I think that the interaction here today between SIMC and SIAC is proof that that need not necessarily be the case. So perhaps I can open with a rather broad question, and perhaps if I could direct this at Justice Jeyaretnam, about where, Judge, you see the dispute resolution ecosystem developing, and where you see perhaps greater areas of interaction between these three pillars of dispute resolution.
Yes, certainly. I think that, the first thing to do is we do have to frame it in terms of what kind of disputes we are talking about. And there's no doubt that the mix of modes of dispute resolution will differ considerably depending on what the nature of the dispute is. But I think the topic this evening is limited really to sort of commercial disputes, perhaps even limited to international commercial disputes, since after all, the first two words of our respective organizations are the same, Singapore and international. So I suppose we could put it in that in that way, and I do think that what we will see continue to develop is disputes having multiple pathways and the same dispute. It was something that I'd sort of touched on. I really do think that we will increasingly see, because disputes have become so large, right? Some of them have become so large. When we talk about small disputes, there are different issues altogether, like costs and so on, that become really controlling as to how they are to be dealt with under any system of justice. But in terms of large disputes, we've probably reached a point where the ingenuity of lawyers and the advances of technology in terms of the amount of documents that are created in any transaction really perhaps exceed the capacity of the human mind, one human mind. And this old model that the judge sits there with, like a blank slate waiting to be filled up by the lawyers, well, I'm afraid it's just you're likely to overwhelm the judge, right? So you need different tools and methods to make a dispute more manageable, and more manageable in a reasonable length of time and at reasonable cost. And that is where certainly, perhaps arbitrating a particular aspect of a dispute before an industry expert. I mean, accounting issues, for example, very often can be dealt with among accountants rather than involving lawyers at all. I don't want to deprive anyone of work, but that is an example where part of a dispute can be hived off to an arbitrator who is an accountant. And then, of course, I'd mentioned mediation, and it might be that you want a decision from the court on the contract and what the meaning of the contract is, and then you might want to mediate for example, the defects issues, having established the parameters first in court. And so we will see this different ways of moving in and out or between the different modes of dispute resolution.
Thank you. Remain, Gloria, anything you'd like to add? Gloria.
If I may, I was just thinking of disputes, settlement mechanisms and the way we view them. For us, of course, we view arbitration as one track, mediation and then litigation, sometimes as separate tracks. But actually, if you think about it in the way a user would look at it, it's actually a continuum of different options. And when you look at the options, I think what we are seeking to do is to find the areas of where there is what we could call complementariness, right? Where we could complement each other and offer the user a new tool that they can put into their toolbox to use appropriately to the dispute. So I think from the Singapore as a seat perspective, that's a very useful approach because it allows us to be creative. It allows, I think, practitioners to give different solutions to clients and tap on these various mechanisms that we've come up with to give the best solution, a best designed solution for the dispute.
Thank you. Just to pick up on one point you made there, Gloria, where you talked about offering users tools to resolve their disputes. One of the things that SIAC has done pursuant to this clause is it's agreed to amend its recommended clause to insert wording or an express agreement to commence arbitration-related court proceedings before the SICC. How do you see that benefiting SIAC's users?
I think at the end of the day, and I think as Minister had shared, and arbitration is about party autonomy. And at the end of the day, the parties have to design their dispute resolution option. For us, when we offer a model clause, it is to make things easier for them. We recommend our model clause because it has been tested in the courts, the wording works, and it's easy, plug and play. And so in we are adding the SICC jurisdiction clause as an option within our usual model clause. And this is in the context of cases where the IA is to apply and it is seated in Singapore and it is international in nature and parties find that there is benefit to it. And I think from the user's perspective, I think there are benefits to tagging on this clause in international cases because the rules in SICC are really designed for international cases. And I think this applies to various parts of the processes as well as the costs, right? And I think this makes it attractive for a user, right, to have that facility. I think the other is the SICC has an international bench, and the expertise that is needed in different cases may involve not just common law but also civil law issues, right? And I think that will also be a benefit if the users choose the clause for Singapore-seated arbitrations.
Yes, and if I can take off my moderator hat and speak as a practitioner, one of the things as an arbitration practitioner that I've found is where we've increasingly seen applications to set aside arbitral awards. And as Judge has pointed out, some of these are not the strongest in terms of legal substance. And some unhappiness arises where even though you've won your award and then you've successfully battered away a setting aside application, you've still had to incur some costs out of pocket because under the old Order 59 principles, you couldn't get an indemnity for costs, and there's a decision on that. But I think the Court of Appeal has now indicated that for SICC matters, the principles for cost recoveries are different. And you look really at the reasonableness of the cost actually incurred. So that's something that I see perhaps as one benefit of arbitration-related hearings moving to the SICC. And I wonder, Judge, whether that's something you would want to comment on.
Well, I think it's obviously the natural decision based on the based on the framework of the institution and the purpose which the institution has, which is to serve an international commercial clientele. And so that decision brings or actually just more makes clear that this is how the SICC will treat costs. And I do appreciate, yes, from the point of view of an international commercial party and as a former practitioner myself, I'm well aware that parties would want to have closer to full recovery. That just makes sense for them, and so I'm sure that is going to be one reason why parties might want to come to the SICC if they are international and commercial.
Can I just pause here to say that we're happy to take questions from the floor. We will have a section for questions and answers at the end, but if there's a particular topic that you feel you want to contribute to, please raise your hands and I'll get to you. Yes, the gentleman over there.
Thank you all very much. Do I need?
No,
Can you hear me?
Yes.
Thank you. I echo what the judge has said in relation to not mediating in a vacuum. So it's a most welcome development to have yet another tool lit. My question is really for the SIAC, which is, whilst I fully understand, and in fact it's a great benefit for practitioners to have the SIAC ask for deposits and advances and tranches, it relieves us of the burden of getting the money.
Sorry to interrupt. Because we have those online also, so we got the microphone.
Hello, is that better? Thank you. Whilst I understand that the reasoning for advances, I'm afraid to say sometimes the timing of those advances can be somewhat clumsy. For example, you can find yourself, even before the first procedural hearing, having to advance 80% of the estimated arbitral fees, and where you have a situation where a respondent is recalcitrant, doesn't have a counterclaim, and is not paying his share, that's a real burden on the claimant. However, that's a minor point. My main point is if you have ARB, Med ARB, and you may not even have got to a procedural hearing on the arbitration before it's suspended, what is the attitude of the SIAC to the amount and the timing of demands? Because it needs to be handled with care, otherwise the alternative option is going to be very beneficial. Thank you.
No, thank you for your feedback. And I think these are the types of feedback that we need in terms of the processes that we have. And, these are practical issues indeed. We have the ARB process, and I think one of it is, it's a process that we've had in place for a while. And I was going to share that by experience, though, we've had to run it through a few cases and to see how we can fine-tune some of this. So far, I think on the, in practice, it has taken a while for people to get used to this process and to take this on. So we have about, based on our experience so far, we've got close to 30 recorded cases. I think that is a good start. We have seen mediation being useful in that context. I do not know of whether the issue of deposits has come up as an issue, and if you have a specific case that you can share with us, we'd be happy to look at the issues that came up. But that said, I would say that based on our experience with the ARP protocol so far, while the numbers have not been that large, the users have been very international in flavor. And in fact, I had a list of the kinds of jurisdictions that these parties had come from, and not just Singapore, but we had parties from Germany, Indonesia, UAE, India, USA, China, Japan, Korea, Vietnam, Switzerland, Thailand, to name a few. So I would say that for that, there is interest, right, in using hybrid options. And I think we do admit when we introduce such mechanisms, there will be procedural and administrative things that do need to be sorted out to ensure the smooth running of this. So I appreciate the feedback, and do let us know if there's a specific case that we should look at. Thank you.
Thank you, Gloria. And if we can stay with the hybrid process and talk about, sorry, Edmund, I'll come back to you in a minute. But if we can stay with the hybrid process and talk about lit, met, lid, I got it right. If we can talk about lit, met, lid, maybe Wee Meng, if you can talk to us about why what's the rationale behind this clause? Because the SIMC, or rather the SICC rules, already encourage parties to actively look at mediation, and why then was it considered necessary for this express protocol to be introduced?
Thank you, Siraj. Maybe before I start, I have to just say something about what Lawrence was saying earlier. Siraj is actually one of our specialist mediator, and he has done some mediation with us, but in line with his modest way, you know, he hasn't publicized that much. So thank you, Siraj. So with regard to why lit, met, lit was introduced, actually it started a while ago. It's not something that we just started this year. For those of you who know Julian, who was my deputy earlier, it started that long ago. But it took a bit of time to take steps, because at the end of the day, we are looking at the parties' wishes, the parties' plans, and to what Judge was saying earlier, and also Minister Tong. At the end of the day, we are trying to address the wishes of parties. And if I may take off my hat as CEO of SIMC and take on sort of my former hat as General Counsel when I was in-house, from a user's perspective, it is very important that when you have a dispute, you have different options in front of you. And you have the ability to say, let's go to Singapore and have this matter resolved, and have different options available, not only at the start of the dispute, but in the midst of the dispute itself. And so when you have those options available, it just makes the confidence of the parties a lot higher in resolving those disputes one way or the other, by a final award or by mediation. And so the way that we've designed lit, met, lit is in such a way that it's not only at the start of the litigation, which of course parties can have the 8 weeks that we've set aside for the mediation, but also any time during the course of the hearing itself, during the case management, etc., both the parties and the judge are in a position to suggest mediation. And I think that's really the power behind it, because as Judge has said, really for each case it depends on the sweet spot of when mediation is appropriate really differs from case to case. We've had cases where a mediation is successful after a judgment. You think about it. After a judgment, they still went for mediation. That's highly unusual, but that happens. And as long as you're able to meet the concerns of the parties, I think that gives the parties a lot of confidence. And I was saying from an in-house perspective, that is very, very attractive. And of course, when you go to both SICC, SIAC, and SIMC, you have the confidence that there is a separation when a matter is referred from SICC to SIMC or from SIAC to SIMC. There's a clear separation, but still a one-stop process. And to the question earlier from the audience, it is important also for the clients to feel that when they submit that case for Ahmedab to SIAC, that there's a seamless transfer of the case to SIMC without having to refile, without having to do all of that registration. And again, it's really for the ease of use, for the seamless process that has been put in place. Thank you.
Edwin?
Hi, thanks. Edwin Cronenberg from Brattle Brothers. I'm a Singapore practitioner. I'm sort of wearing my hat here as a Law Society member and a committee chair. The Law Society actually, in relation to alternate dispute resolution, has a guidance note for practitioners that when they face a dispute, they should be telling their clients that they have the options of arbitration, mediation, etc. First question is, what is the triumvirate doing to engage with the Law Society to ensure that this actually gets to the people who are advising clients on the ground when a dispute arises? Because we really shouldn't be separate. We should be working together on this. And I completely agree with the ethos of appropriate dispute resolution to cut the cloth for the particular dispute. The second question is this. The SIAC clause is now extremely long. It's got about 3 options. Dispute resolution lawyers do not draft these things into contracts. They are drafted by corporate lawyers. 1, do the corporate lawyers understand the different options and how to choose between them? 2, do they even care? Or do they stick something in at the 11th hour? And if we don't have answers to those questions, then this room should be filled with corporate lawyers who you should be educating on the different options and the different pathways. Questions for you to address. Thank you very much.
So maybe if I can take a stab at that first, in speaking with a SIAC hat on. I think there has been a very deliberate attempt to engage corporate practitioners, not just in Singapore, but also overseas, in understanding how the SIAC clause works, when it's incorporated, what it entails in terms of the different provisions of the SIAC clause, like the seat of arbitration, etc. Whether that eventually leads to parties considering an arbitration clause earlier than the 11th hour, it's really out of our hands. But I think there's been a lot done to engage, and maybe Gloria can expand on that as well.
Yes, I think it has to be collaborative, as you said, Edmund, and indeed we do want to work closely with the bar. It is important that we have a relationship with the practitioners, and also, there is an awareness of all our initiatives. So, we appreciate your sharing with us the Law Society, these efforts here, and I think there's always scope for collaboration and promoting some of these best practices. In terms of the clause, I would say, I have to say, back to my point about dispute systems design, this is a work in progress. We are going through an evolution of dispute resolution processes. I mean, those of you who were around 20 years ago, arbitration was a different creature that it is now. And I think some of these clauses and some of these things that we have developed over time may need review from time to time to ensure that they are ergonomic to users and ergonomic and likewise process, right? Payments, when do we do it? When do we get parties to do this and that? I think these are things that we can review, and I really appreciate the participation of the legal community and arbitration community here in giving us the feedback and letting us know where we can do better. So thank you for all the comments so far.
May I add to that? So this was a couple of years ago before COVID, and I remember that we were on a stage. I think, Gloria, you were with Min Law at that time, and Lawrence, you were there as well. We were talking to the members of the Law Society is in one of the universities, as I recall, talking about AMA, talking about disputes, and true, we should be doing more. There's no doubt about it. We should be doing more, and we should have more events like that, directed not only at the dispute lawyers, but also at the transactional lawyers. And if I may add, what is very interesting in mediation is that we find transactional lawyers very, very good mediators. They make very good mediators. And certainly from our perspective, you know, when we look at mediators, we're not only looking at dispute lawyers, we're also very open to transactional lawyers trained to become mediators, and some of our most successful mediation has been by transactional lawyers. And I think that's in a way of reaching out to them as well, because not only are they incorporating a clause into the contract, potentially they are benefiting one of their own down the road who may be a mediator for that particular dispute. So certainly take your point, and we can certainly do more. Thank you.
Are there any other questions from members of the audience? I think I should apologize to those of you who are online. It's difficult to get questions from you, but you know their email, so you can email them directly. I said I was mindful that we are drawing towards the end of the time that's been allocated, and I want to leave some time for the networking and for us to sort of meet each other. So I'm going to try and draw this to a close by perhaps inviting Gloria and Wee Ming to say some words, to anything that they'd like to say to end off this session.
Well, I think coming out of the Q&A, I think there is room for collaboration for us to really put together our minds and our ideas to look at ways in which we can really tailor appropriate dispute resolution processes for users. And so, on behalf of my institution, I'm very happy to engage with you, and I look forward to speaking to everyone during the tea break.
Well, for me, I think the success of the lit-met-lit protocol will come from successfully mediated cases from a SICC case. So we're just getting started here. We've seen some really good success coming of AMA that Gloria talked about. We're not always able to talk about it because it's confidential. So we hope that with more cases coming to SICC, with the lit-met-lit protocol, we'll have more success stories that we can share. Some of it will be anonymized. Some of it, maybe the parties are open to sharing it, or maybe there'll be some regulatory requirement that allow us to share this. So with these success stories, I believe that it will help to grow the use of mediation across the region. And I'll tell you that whenever we go overseas to, whether it's China, Korea, Japan, they're all looking to Singapore in a sense to say, I think the way that we have collaborated is something that they see as a role model to some extent, and I think we should do more, not only amongst ourselves here, but also across the different countries, whether it's in Japan, Korea, India, etc. So I look forward to those of you who can't join us in person, who are online. We look forward to visiting you and really collaborating across the regions, because at the end of the day, it's the interest of the clients, the interest of the parties that we have in mind when we talk about the appropriate dispute resolution.
Thank you. Judge, any closing comments for us?
Yes, I do actually. Siraj, you know me well, so you realize that you probably did need to turn to me, because otherwise I would feel that I'd missed an opportunity to speak, and I usually don't miss such opportunities. But I really wanted to actually respond to what Edmund said, because I think it also has application to the work that we do here in the courts. And I'd like to frame it like this. First of all, I think there's a difference between users and engagement with users and promotion, right? So I don't think the court is really interested in promotion, right, in the way that, of course, SIAC or SIMC might do. So that's not something we do. But we are very keen on engagement with users and that transparency with users. So we have set up in the last, very recently, users committees, for example, for arbitration, and we will have our first meeting of that, I think, next week. I think it's next week, or maybe the week after. Yeah, next week is Chinese New Year, so the week after that. That involves the Law Society. One of some of the nominees have come from the Law Society. And we will also be setting up a Users' Council for the SICC as a whole. And I really do share what your feeling about, engagement, right? And it has to be in a transparent and open way. And with the users, we would very much like to have, for example, an open meeting, as this is in a way, but specifically an open meeting that the Users' Council can be involved in, where anyone can come. And we'll have that engagement on, on processes. Not, of course, to grumble about having lost a particular case. I mean, those grumbles, you have to grumble to the mirror, I'm afraid. But of course, about processes and charting a way forward. That I think is very much an important part of access to justice generally. So thank you, Edmund, for bringing that up.
Thank you, Judge. Can I close by making 2 points? The first, to echo what Minister said, which was that a lot of this process works best when it's driven from the ground up. And all of us as practitioners have probably the closest contact with users. So I think it's important for all of us to play our part to ensure that feedback first is obtained and then passed on to the relevant people, so that all of us who are participants in the Singapore dispute resolution ecosystem can benefit. And secondly, and perhaps more importantly, to join me in thanking the members of the panel for coming today in the usual manner. And thank you all for attending in person, and also those who have been online. We hope you've had an enjoyable fireside chat. And for those of you who are here, I think on behalf of Lawrence and the SICC, can I invite you to the reception?
No, not yet.
Not yet. I'm sorry.
Sorry. Siraj, thank you so much. And
thank you.
Panel, thank you for such a wonderful discussion on this thing. For a while, then, can I just invite everyone, the panel, to just be in front. We need the mandatory, customary group photo. Just bear with us for a while more, ladies and gentlemen, just for a quick one. In front of the coffee table, yeah. Yes. And slightly towards Siraj. So we have the pull-up banner, you see, over there. Ben? Okay. Thank you. A few more minutes. Judge, Siraj, can I just ask you to remain here? Judge mentioned during his address about a working group that helped us come up with the IAA model clause. And simplicity is actually a key essence, but they did spend many hours going through it in order to get it there. And even though, notwithstanding the hours that the working group took to meet, nine of the lawyers together with our divisional registrar, Pang Xiao Chung, but also I don't want to know how much would have been the cost if they had charged out at their charge-out rates on that. So individually, a small token of appreciation from to be presented by Judge as President of SICC. Firstly to Siraj. Then Siraj, can I ask you to remain on stage? And then to Ashish Kabra from Nisha Desai Associates. Siraj, just wait. I need another group photo in a while. Yeah. Chong Yi Leong from Allen Gladhill. Thomas Furlong from Herbert Smith Freehills. Tom. Our ever effervescent Francis Xavier SC from Rajasthan, Asia. Unfortunately, as an indication of how borders have reopened and everyone is on a busy schedule, 3 of them are not able. I'll just mention them for the record. Amanda Lee from King and Wood Mallisons, Leon Ryan from Anderson Mori and Tomotsune, and Seongmin Lee from Peter and Kim. They're all there. And no, I did not miss out somebody, but only because I want to make a special mention. And Judge has actually alluded to it. The inspiration for all this actually come from the last but not the least member of the working group, Paul Tan from Gibson and Dunn, who not only has done that, but also has kindly gotten Gibson and Dunn to sponsor the marvelous reception that we're going to have after this. So, Paul, thank you in more ways than one. Thank you so much. And one last, one last final part, the mandatory photo again. Can I have the rest of the working group together, our divisional registrar, for just to be up front, and we have a nice, quick group photo on that. And then we can all hit the drinks and the food. Yeah, but having said that, the rest of, ladies and gentlemen, please rise and help yourself to a cocktail at the back. Okay. Thank you, thank you. Thank you. Just right here.
Early morning.